Hi, everyone. Welcome to our webinar today on preparing your business for success in 2025. Thank you so much for joining. So my name's Olivia. I'm a senior associate in our commercial team here at LegalVision. So I look forward to chatting you through some of the key points that we've prepared for today's webinar. Just before we begin, just a few quick housekeeping items. So you will receive the recording and the slides from today's presentation. So you'll receive that to your email that you provided. You can submit your questions in the Q&A box and we'll aim to answer those at the end. We also had a few pre-submitted questions that we'll answer as well. And we would really love if you could please complete the feedback survey, very short at the end of the webinar, just allows us to make sure that these are really useful for people moving forward. So just to cover as well, so for the next 48 hours, you're eligible to receive a free consultation with LegalVision to discuss how we can help your specific business and talk about your business in more detail. So to claim that consultation, please provide your contact details in the survey at the end of the webinar, and our team will get in touch today. Wonderful. So in terms of what we'll be discussing today, we're focusing on sort of key commercial areas of law. So we'll talk through some employment law updates, some changes to data and privacy legislation, UK companies law updates. We'll talk about the Digital Markets and Competition Consumers Act, and also having the right contracts in place for your business. We'll also do a bit of a Q&A at the end of today's session. All right, so we're just going to do a really quick poll just to get a little bit of a gauge for kind of what you're looking forward to addressing today. So if you could answer just the poll question, which is, what's your top priority for preparing your business for success in 2025? So if you could pick from the options, we've got upcoming law changes, ensuring compliance with 2025 data and privacy obligations, understanding the new Digital Markets, Competition and Consumers Act, reviewing and updating contracts, and just staying informed and exploring options. So I'll give you guys a sec to answer that multiple choice question. Hopefully you've all had a chance to submit your answers. We'll close that now and see what the results are. Brilliant. So I can see those results. So I've got quite a few people looking for some understanding of privacy, the DMCC Act. Just getting informed and exploring your options is also a very a good place to be as well. Awesome. Thanks, everyone, for answering that question. So we'll get started with today's webinar and cover some of those topics. So the first one that we'd like to chat about is employment law changes in 2025. In terms of this topic, I'm not going to go into too much detail because we actually have a dedicated webinar next Tuesday on employment law changes, which I'll provide some details of as well later in our webinar. So we'll just at a high level kind of cover those employment law changes. So there was a big sort of array of changes in 2024, and further changes are expected in 2025 to employment law. So a number of changes as a result of the Employment Rights Bill, which has come from the new Labor government. There's quite a number of changes that they're proposing to make. And so we're expecting to see that pass as law in 2025. And then expect to see the kind of rollout of those changes more than likely in 2026. So the Labor Party, as I said, has proposed a number of wide-ranging changes to employment law contained in that Employment Rights Bill. So there's quite a wide-ranging number of topics that they're looking to make changes to, including in relation to unfair dismissal, firing and rehiring employees, collective redundancies, zero-hour and low-hour contracts, trade unions and industrial action, sexual harassment and third-party harassment, statutory sick pay, flexible working, and family leave. So quite a number of topics there. Now, we'll focus a little bit on some of those kind of key ones for businesses The first one being unfair dismissal. This is a really big one. So currently at the moment, an employee, unless there's sort of a number of sort of very select exceptions to this rule, but essentially at the moment, an employee can only bring an unfair dismissal claim once they have been employed by the business for 2 years. Now that is going to be scrapped, and so an employee can bring a claim for unfair dismissal from day one. So we expect that change to likely be effective in 2026, and we're expecting some more guidance on kind of what that will involve. Firing and rehiring, so that's a big one. The bill will seek to limit the circumstances in which a company can fire its existing staff and rehire them on less favourable employment terms, or hire a new workplace to replace its existing staff. It will also make it automatically unfair to dismiss an employee for refusing to agree to a change in their employee contract, except in certain circumstances where a business can, for example, like a business's financial circumstances, could be an exception to that rule. And for 0 hours and low hour contracts, the bill will seek to make it mandatory for an employer to offer guaranteed hours for 0 hour workers to qualifying workers, as well as a duty for the employer to give reasonable notice of a shift, as well as paying compensation for shifts which are cancelled or moved on very short notice. So that will be a really big one to look out for businesses which engage their workers on 0 hour contracts. In terms of more immediate changes for 2025, the national living wage will increase on the 1st of April from £11.44 to £12.21 for adults aged 21 and over, and will increase from £8.60 to £10 per hour for adults aged 18 to 20. The statutory rates will also increase for 16 to 17-year-olds and also apprentices. So if you've got a business and you're engaging workers, you should absolutely be across the increase to the national minimum wage. Statutory sick pay, maternity pay, and other family leave entitlements will also increase from 1st of April 2025. From the 6th of April 2025, a day one right will be implemented for employees, allowing them the right to neonatal care leave. So this will apply to parents of babies who are admitted into neonatal care up to 28 days old and who have a continuous stay in hospital of 7 days or longer. So eligible parents will be able to take up to 12 weeks of leave, and if eligible, pay on top of any other leave that they may be entitled to, including maternity or paternity leave. So that's a little bit of a kind of snapshot of some employment law changes to keep out for. As I said, we've got an dedicated employment webinar, which is next Tuesday. So you can join my colleague Comfort, who is an employment practice leader, next Tuesday for a webinar on that topic. Just some quick employment law action items to cover off. So as said, review your staff wages in line with the update to the national living wage on the 1st of April. Review your employment contracts to ensure that they are up to date with 2024 and 2025 employment law changes. Review your employee policies to ensure that they are up to date with current entitlements. Make sure your health and safety policies are up to date, which is a really important one. And just keep updated and sort of, alive to any progress of the Employment Rights Bill, because they are quite substantial changes that will affect businesses, and just so you know when kind of various new measures will be coming into place. The next topic is 2025 data and privacy obligations. So obviously in the UK, privacy is a key consideration for businesses. Almost all businesses deal with personal data. Of course, they need that to understand who their customers are, who their employees are, their contractors, etc. So it's legislated in the UK under the Data Protection Act, which incorporates the UK GDPR, and for direct marketing under the Privacy and Electronic Communications Regulations, which is also referred to as the PECR. So the regulator that enforces these pieces of legislation is the Information Commissioner's Office. We'll refer to them as the ICO, and the ICO will be focusing in 2025. They've said that their kind of enforcement priorities relate to online advertising, and this includes things like cracking down on cookie compliance and direct marketing violations. So we're really kind of seeing a continuation, from their 2024 priorities, but really a focus on online and direct marketing. So we'll touch on cookie compliance briefly. So in regards to cookie compliance, when you are using cookies on your website as a business, so those are little sort of little pieces of data that essentially get put onto the customer's device. You are required to get consent before placing any non-essential cookies onto the user's device. The way you can get consent, and we all will have seen it before, is when you go onto a website, you're asked to consent to cookies through a cookie banner, which needs to give people the choice to accept, reject, or manage their preferences in relation to non-essential cookies. So if you're using cookies on your website, and definitely a good idea to check that with your developer or whoever manages IT in your business, you should absolutely make sure you've got a compliant cookie banner in place, which is functioning and working. So in 2024, the ICO assessed the cookie banners of the top 200 UK websites, sent notices to over 130 of those businesses who were non-compliant or required improvement in their cookie banners. And this year, the ICO plan to expand that to the top 1,000 websites in the UK. So they're really trying to make sure that the most visited websites in the UK are compliant with cookie legislation, and that applies for small businesses as well. In the ICO's guidance that it has provided on cookie compliance, it says that non-essential cookies cannot be placed until the user has consented. So that's obviously a really key one. Users should be able to reject cookies as easily as they can accept them. So obviously best practice would be to have a banner which allows people to accept all and reject all really prominently, sort of those buttons next to each other. Once a user rejects non-essential cookies, obviously make sure that your systems are not placing cookies or tracking that user using cookies once they've sort of given that instruction to you. And your cookie banner should also have a function to allow people to remove their consent or revoke their consent at a later date. So really interactive cookie banners or cookie policies with the ability and function for people to change their preferences are very, very important. So the ICO's focus for 2025 is to ensure that online tracking gives people really clear choices for how their information is used and confidence in how their information is used. We'll touch on some recent guidance as well from the ICO, which was published last week, which is to do with consent or pay models for the use of cookies. So you may have seen, or you may be using in your business, basically an option to basically say that a user must consent to the use of non-essential cookies to continue using a website, or pay to not have their information tracked using cookies. Now, these are kind of being used increasingly in media websites and other websites. So the ICO has released guidance to say that if the business is giving the user an option to consent to personalized advertising and access the content for free, they need to make sure if they're going down the free or paid model, it can be lawful as long as the business shows that genuine consent has been achieved. And the factors to determine whether genuine consent has been given by the user is there a power imbalance between the business and the user? So does the user really rely on that website? Are there other options available to them? Is the fee appropriate? Does it actually kind of represent what value individuals put on the use of their data being used for direct marketing purposes, whether the options have been presented clearly and in accordance with privacy by design. So that kind of means, is the option really clear? Is it really clear to the user that by proceeding and not paying that they are having their information tracked? Is that really clear to the user? And the consent or paid options need to provide equivalent core services as well. So that guidance is really useful if you are looking to implement a consent or pay model, or if you come across that in your business as well. Lastly, the ICO has been cracking down on spam and nuisance calls, particularly businesses who make unsolicited phone calls to individuals, especially if they're registered for the telephone preference service, TPS. So if you are making direct marketing calls using, obviously phone marketing. Absolutely should be checking against the telephone preference service. So businesses that have been making those spam and nuisance calls have faced enforcement action in the last 12 months and will continue to do so. And lastly, in terms of cybersecurity, I thought we'd really make you aware of the National Cybersecurity Centre have a free cybersecurity toolkit for small business. Really, it's free, and I really recommend that you access that for, information and guidance on how to keep your business safe against online criminals. A couple of just other little sort of items to deal with on privacy point is the Data Use and Access Bill is making its way through Parliament and is likely to pass in 2025. So the intention of this legislation is to regulate smart data, such as open banking system, to create a regulatory structure for digital identities online and verification services for those digital identities. And we could see some amendments to the UK GDPR as well. So definitely one to keep an eye on, and we will certainly be keeping abreast of the developments there. Lastly, the UK's adequacy status for data transfers from the EU is coming up for renewal on the 27th of June this year. So we have to await the European Commission's decision on whether the UK is still deemed an adequate jurisdiction for the transfer of data from the EU to the UK. We don't see any sort of obvious barrier to renewal, but the passing of the Data Use and Access Bill will certainly be a consideration for the European Commission. So we'll keep an eye out for the effects of that. So just a bit of a checklist for privacy. Update your privacy policy. This should be done annually or when your data practices change. So really just making sure that you're giving an update to your privacy notice. Make sure you've got valid data processing agreements with all third parties processing personal data on your behalf, or your contractors or your software suppliers, etc. Review your cookie banner. Make sure you've got adequate consent. Review your internal policies, such as your data breach response plan. Do you know how you'll respond if you potentially have a data breach? And how long are you retaining data for, and are your employees aware of all of this? Obviously, training staff on identifying data breaches and handling data subject requests is a really important one. There are statutory timelines and deadlines for responding to data subjects or notifying data subjects and the ICO in the event of a data breach. And you really need to be aware of those. And then obviously using the free My Cyber Toolkit for cybersecurity guidance as well. Okay, so the next topic is company law. We saw plenty of changes in 2024, an increase in fees by Companies House, and then a requirement to have an appropriate address as a registered office, so no more PO boxes. So in 2025, we'll continue to see the rollout and the effects of the Economic Crime and Corporate Transparency Act, which was the biggest change to Companies House since it was established in 1844. So in 2025, we expect to see a number of key changes come into effect, all in line with their kind of goal of increasing accuracy of the Companies House register. Really important one, we don't have exact dates yet, but we're kind of expecting autumn 2025, but that is identity verification. So anyone setting up, owning, running, or controlling a company in the UK will need to verify their identity to prove that they are who they claim to be. So all directors and PSCs, persons of significant control, will need to complete identity verification. For existing companies, that will kind of be a rolled out process. Certainly for new companies registering, the identity verification will now form part of the company incorporation process. So the other thing to note is on the 1st of September 2025, it will become a criminal offence where a large organisation fails to prevent fraud by an employee, agent, or other associated person which benefits the organisation. So that will affect, and that rule will affect businesses who meet 2 or more of the following criteria. See that on the slides. They have to have 250 or more employees, more than 36 million turnover, or more than 18 million in total assets. If you meet 2 or more of that criteria, certainly need to be aware of that implementation and need to prepare procedures and policies in place for presenting fraud in your organisation as a defence to a potential claim there. A second reading of the Company Directors and Duties Bill is scheduled for 4th of July 2025. So this bill will intend to amend the Companies Act to ensure that directors balance their duty to promote the success of the company with new duties now to promote the success of the company for its employees and also for the environment. So we're really interested to see the guidance on that and sort of how the balance of, success of the company for members will be balanced with its duty to employees and the environment. So some company law action items for you. Ensure your company registers are up to date. That should be all your list of shareholders, directors, PSCs, etc. Make sure you're filing your annual confirmation statement and accounts with Companies House and doing so on time to avoid being struck off. If you have multiple shareholders or directors, you should have articles of association and a shareholders agreement in place to really kind of reflect the obligations and sort of the intimate circumstances of your company. So make sure that those are up to date and currently meeting your business needs. And you should absolutely monitor emails from Companies House. Do not ignore those in relation to identity verification, which will be rolling out this year. So that's a little bit of a highlight of companies law. The DMCC Act. So I know this was a priority for quite a few of you. So the Digital Markets Competition and Consumers Act is a really important piece of consumer legislation passed in 2024 and will continue, was first implemented the 1st of January and will continue to see reforms roll out over the next year or two, basically. So from the 1st of January, what we've seen really is a focus on the rolling out, and the effects will be kind of mostly for larger businesses and larger tech companies. So the initial changes are focused on competition law reforms. The Competition and Markets Authority, the CMA, has established the concept of strategic market status for tech companies with dominant positions in digital markets. So those companies now, obviously we're thinking here, Meta, Google, Apple, they're going to face tailored codes of conduct and increased scrutiny to prevent market abuse and encourage competition in those markets. So it's aimed at ensuring that those businesses treat consumers fairly. So the changes largely don't affect small businesses. It's targeted at those big companies who have a big market status. The CMA have already taken this sort of action with strategic market status against Google and Apple. So we're really interested to see kind of the effects of those investigations by the CMA. So the next batch of sort of changes will be in April 2025. Now, these relate to new customer and consumer enforcement rules and changes to unfair trading regulations. The Competition and Markets Authority, the CMA, will now be able to directly enforce consumer laws and enforce businesses, penalties on businesses directly. Largely it was only the courts that could do so. The big change is that previously there was no penalty for breaching a large number of the consumer law regime, including unfair contract term provisions in consumer contracts. But this is changing as of April 2025. It will become a criminal offence to engage in unfair commercial practices, including misleading actions or omissions, aggressive sales tactics, and failing to meet professional due diligence standards. So companies and their directors or managers could face fines or up to 2 years in prison for serious violations, such as engaging in unfair commercial practices. So the Act now empowers the CMA to impose penalties directly on businesses which breach consumer protection laws. So as I said, big shift. There was no financial penalties previously. So the fines can be significant. It's going to be up to the greater of 10% of global annual turnover or £300,000. So to avoid penalties, businesses really need to be going through their consumer contracts, making sure that they're compliant, not containing unfair contract terms, and that your policies comply with all your consumer obligations. So, the other thing to note as well for 2026 for subscription businesses is to note that consumers will be given a 14-day window to cancel after a subscription automatically renews, in addition to their rights to cancel within the first 14 days of their contract. So just note that those rules are coming into effect for 2026 if you have a subscription-based business. My colleague Hammy, who's a commercial senior associate, will be running a webinar on this topic on Tuesday, the 25th of February. So if you're interested in learning more about the effects of the DMCC Act, please do register for that webinar. So some consumer law action items. Update your consumer contracts to ensure that you're using plain, easy to understand language in your consumer contracts. Obviously, avoiding any unfair contract terms in your consumer contracts. Businesses really need to understand whether they're obligated to offer a 14-day cooling off period for online, phone, or mail order sales. So you really need to get advice on that. And obviously, if you do have an obligation, to make sure that you give consumers those rights. Enforcing and ensuring your refund and return policies do comply with those cooling off obligations, and making sure that you handle complaints regarding faulty goods or services in accordance with the consumer's right for prompt repair, replacement, or refund under consumer law to avoid any consumer complaints and potentially escalating to a situation where you might be liable for a fine or criminal action. Now, last topic we're going to quickly touch on is whether you have the right contracts in place. Now, this will obviously depend on the type of business you're operating and who your customers are. For consumer contracts, we've just touched on consumer obligations, but particularly with those penalties coming into force this year, you should ensure that all of your contracts have clear and transparent terms, compliance with the Consumer Rights Act, that there's fair cancellation and refund policies and clear pricing information, and compliance with those distance selling regulations we touched on. So 14-day cancellation rights for goods commencing the date after the goods were delivered, and a 14-day cancellation right typically for service contracts, which commences on the day that they enter into the contract. So getting advice and making sure you've got the right refund and return policies in place and cancellation policies. If you supply goods, your contract should have a clear description of the goods being supplied, delivery terms and timelines, warranty and risk return policies, if applicable, obviously, risk transfer and title transfer. So that's really important for kind of who's responsible for shipping and insurance. And then payment terms and methods, including a right to reclaim possession of the goods if the purchaser doesn't pay. And that's particularly important if you're doing goods on credit and to business customers. For service contracts, you should really have a clearly defined scope of services to prevent scope creep, particularly in creative industries, limitations on service levels and performance guarantees, particularly for IT contracts, change control procedures for variations to sort of ensure there's a clear process for how variations are accepted. Some really clear client obligations. If you need documents or you need the consumer to or the client to do certain things, such as sort of give you access to property, that obligation needs to be in the contract. Your right to suspend services if the client isn't paying, particularly if this is an ongoing service contract. Data processing clauses, super important if you're processing personal data in the scope of your services. And for ongoing contracts, we also really need to see auto renewal, typically, if that's obviously the preference for businesses, and also price adjustment clauses if it's an ongoing contract. So aside from those kinds of little important things depending on the scope of your services, making sure that you've got a clear description of the goods and services for all of your contracts. Intellectual property is a big one for all contracts, and a limitation of liability is super, super important to ensure that you're capping your liability to your customer as much as you possibly can, given the circumstances and the type of contract. Okay, so Lastly, contract action items. So conduct a comprehensive review of all of your existing contracts, and if you haven't already, you should develop templates for different types of contracts, so consumer, goods, services, depending on what your business provides. You should ensure that all of your contracts are clearly accepted by clients before you begin performing the services or supplying the goods. We see a lot of clients get a little bit unstuck where they haven't yet signed a contract. And implement a contract management system, whether it's manual or using software, to track and update agreements, including dates for termination and renewal. Review your contracts at least annually for all contract templates to make sure that they're still up to date. And obviously, importantly, we obviously recommend consulting legal counsel to ensure that all your contracts are compliant with current laws and regulations. Okay, so that concludes the main part of our webinar, bit of a taste test and all of those topics. Just to make you aware, we have a publication, our SME legal health checklist. So you can access that by in the resources tab of our website or by scanning the QR code. So I'll give you a minute just to access that if you're using your phone today. And then what we'll also do is make you aware of our upcoming event, which I touched on earlier. We have these webinars typically every couple of weeks, but we've got one next Tuesday, the 11th of February at 11 a.m., where one of our employment practice leaders will go into detail on 2025 employment law changes. So really recommend that one if your business employs staff. Okay, so we're going to answer your questions shortly. We have a number of pre-submitted questions as well as some questions submitted throughout the webinar today. So to give you a chance to potentially submit any extra questions that you might have from today's webinar, just in the meantime, we'll take a minute to talk you through LegalVision's membership offering and what we offer our clients. So by becoming a LegalVision member, your business gets unlimited access to our full team of specialist lawyers for all of your business's usual legal needs. So it's like having your own in-house counsel for a fraction of the cost, which is so important for small to medium businesses. Our team can assist you with unlimited document drafting and reviewing of contracts, unlimited legal advice consultations, including you can touch base with us anytime there's a legal update, and we can talk you through how that affects your business. Unlimited UK trademark application registrations, and much more. So as a LegalVision member, you will never have to worry about the cost of lawyers ever again. It's a set monthly fee. So think of it as having your own in-house counsel, and we'll take care of the business as usual legal work so you can focus on running your business and growing your business. If you're an in-house counsel, we also offer a dedicated service to in-house counsel to manage high volume business as usual legal tasks. So to learn more about how membership, or in the case of in-house counsel, our desk extension product can help you, please do request a free consultation when the survey appears at the end of the webinar, and we'll be able to discuss how that can help. Okay, so we're going to answer some of your questions. So I will work through some of these. We have a question that was just, will you send a recording of this presentation? And yes, we definitely will. That will get sent to your email address that you registered for this webinar with. The next question was, what contract would I need if a client lives in the USA? So really good question. Certainly if your business, I assume, is based here in the UK, you would still want to send them your standard template. Ideally, the contract would still be governed by the laws of England and Wales. That because essentially, obviously, then you know that you're complying with the laws of England and Wales. And if there was ever a dispute, it would go through the UK court system and not the laws of, in the US. So that would be obviously the preference, is to typically give them your standard template. If you were in a situation where you had, or you were kind of, given the kind of power of your client in this negotiation, asked to sign a US contract, a UK lawyer can typically provide commercial guidance on the contract. We can certainly do so, but if it's sort of, you would then be sort of bound by the laws of the US, and be subject to typically to their dispute resolution process, including going through the US courts. So ideally, you would keep that with your standard UK template, and it would still be binding on your US customer. So hopefully that answered your question there. I'll also address some of the pre-submitted questions as well from some of you. So someone had a question about registering as an overseas company. It's a really good question. So for overseas companies kind of looking to establish a presence in the UK, there's kind of two options. You can either set up as a UK establishment or incorporate a UK subsidiary. So the UK establishment option is basically you register with Companies House and you're registering a branch or sort of a place of business for your overseas company in the UK. So it would still be one legal entity. It would still be your overseas legal entity that's entering into contracts, but you've registered that with Companies House. You would need to pay tax on your UK earnings for that business. You need to register with Companies House within 1 month of opening the establishment, and there's transparency laws in the UK, and the Companies House will require all the details of the beneficial owners of the parent company. You have to file annual accounts in the same way that UK companies do. So it's simpler to set up, but it's definitely less common. Typically UK customers and partners and employees will want to be contracting with a UK entity. So generally our recommendation is, if you're operating in the UK, to set up a UK subsidiary that could form part of your overall kind of group structure. So it could be owned by an overseas company, for example, but part of your part of your group structure. So it's a separate legal entity from the parent company. It would be set up as a company in England and Wales. Overseas, individuals can be directors and shareholders of a UK entity. There's no kind of residence requirement. So a lot of people get nervous about that, but that's not the case in the UK. You'll need to file its own annual accounts and tax returns with Companies House. And yeah, definitely sort of has a little bit more credibility when operating in the UK as, operating through a UK company. So there's a kind of a number of considerations. It will be tax considerations, the level of your planned activity in the UK, regulatory requirements in your industry as to whether you set up as a UK subsidiary or a UK establishment of your overseas entity. Hopefully that helped you there. One question was, do you need business insurance as a startup? Definitely yes, would be the kind of the short answer, but I can sort of elaborate a little bit more. Definitely chat to an insurance broker. They're going to be best placed to give you advice on what insurance you need, because it will depend on the nature of your business and what goods and services you're providing. So obviously public liability if you're interacting with the public, employer's liability if you have employees, professional indemnity if you're providing advice or professional services, products liability if you're dealing with goods and supplying goods, cyber insurance potentially if you're an IT service provider or you really rely on IT systems. So there's kind of a whole raft of different insurances that you may need, and it will just depend on the type of business you're operating. Definitely speak to an insurance broker about what your business looks like. They will give you advice on the insurance you need and the limits of coverage that you should have. So contracts are obviously really important to mitigate risk as a business, but insurance is absolutely a must-have in terms of making sure that you also have kind of limited the risks and protection for the risks that contract. You simply can't contract out of some liabilities under law. So you need insurance to ensure that you've got the protection. Question from John, can you provide advice on NDAs? And the answer is absolutely yes. NDAs are a really kind of boilerplate contract that our clients need advice on every single day. So we can absolutely review and draft NDAs. And I think we've got time maybe for one more question. So there was a question around drop shipping businesses and business-related issues. I guess obviously we'll focus on kind of the legal issues that a dropshipping business might face and quickly touch on that. So you have to remember, obviously, even if the goods are kind of coming from a third party, you are still the supplier of those goods under contract, particularly where you're supplying to consumers, which is often the case with dropshipping. You are responsible for complying with consumer law, handling returns, even if you never kind of physically see the goods. So quality control is a big one. Obviously, you will not have direct oversight over the goods that are being sent out to customers. So really need a strong contract with the entity that is actually sending out the goods for you, because you were still responsible to the consumer under consumer law for defective goods. You should still also consider product liability insurance and obviously chat to a broker about that, because as I said, you are still involved in the supply of those goods. As I said, contract with the fulfillment partner is super important. It should deal with remedies for defective goods, quality of goods, how they need to promise that they're going to be of adequate quality and compliant with UK law, how quickly they will ship and send out the goods. You kind of want that to be contractually bound, and they will almost certainly have access to personal data of the customers that they're shipping to. So you absolutely need to have a data processing clauses in there to deal with the data processing aspect of giving access to personal data to a third party. Also, customs and import duties, it's kind of a one that might come up if the drop shipping company is abroad, is okay, are your consumers actually going to be liable to pay customs and import duties? And definitely need to discuss that with the drop shipping provider. I think that actually is pretty bang on for time. So thank you everyone for your questions. If we didn't get a chance to answer your question today, there were some that were quite specific to kind of industry or particular circumstances. We would be more than happy to answer those questions. Please just provide us with your contact details following this webinar, and we can arrange a meeting with you to answer the questions that we didn't get to address, but obviously as well to help understand how our membership can support you. As I said earlier, we do have a survey that will pop up at the end of this webinar. It'll just take 30 seconds. We really, really appreciate all of the feedback. And we really look forward to hopefully connecting with some of you directly in the near future. Have a great 2025 and hopefully chat to you all soon. Thanks so much for joining.